Yes. Having had an opportunity to consider the submissions that have been well made on all sides in this case, our decision will be that the appeal will be dismissed for reasons which we will hand down in writing at the earliest possible opportunity, in accordance with the procedure with which you're all aware. Please treat the draft judgment under embargo in accordance with the instructions it contains, and we will then hand down our judgments in due course by electronic procedure without needing to trouble you any further. I don't think that there's anything else that we can or should say now, because I don't think that the issue with which we've been concerned has any bearing on the proceedings that are ongoing in the family court, which will, I think, continue this afternoon.
My Lord, yes, thank you. The only matter that I think anybody at the bar thinks arises from that is that your Lordship has previously granted a stay on the effect of the declarations and the consequent order to convey that to the Registrar General, and we would respectfully seek to extend that stay until 21 days after receipt of your Lordship's and your Ladyship's written reasons, so that my client would be in a position to consider whether she wishes to make any further applications.
Does any other party have observations about that?
My Lord, only this, that it seems difficult to see how Mrs Justice Knowles could proceed with welfare matters, including in particular the application for parental responsibility, if the stays remain. Certainly we agree that the Registrar of Births and so on, that nothing should happen in relation to the birth certificate. We can certainly agree with that. But we would want Mrs Justice Knowles to be in a position to determine the welfare issues if she feels able to in the course of this.
Well, why would the issue of legal parentage make any difference to those determinations?
Well, our concern is that she may feel inhibited if there's a stay of those declarations. In case the matter goes further, may I just turn my back for a minute? Mr Eaton rightly reminds me that we would be applying on the basis that he is the father, so that he is the legal parent. But it's a question of whether Mrs Justice Knowles would feel she can proceed on that basis if there's a stay in place.
Well, you still have a judgment in your favour.
Yes.
And you have the knowledge that the court has dismissed the appeal.
Yes. Well, if this court is content with that, I'm sure Mrs Justice Knowles will be.
Yes, Mr Turner.
My Lord, all right to this. First of all, I understand why Professor George makes the application he does. Of course I do. And I'd have no objection to that. As far as the position in front of Mrs Justice Knowles, obviously if there's still any prospect whatsoever that her original decision would be reversed in relation to F being the father, then that would inhibit the implementation of any decision by her subsequently to grant parental responsibility to him and possibly other matters. But there's no reason I would have thought why she can't go ahead and consider those things de bene esse, as it were, on the basis of the information we have at the moment, and to be confirmed once.
Well, can we break this down then? There's the issue of the registration of the birth certificate, which I very much doubt is likely to take place within a matter of measured in days, but nevertheless I can quite see why a step of that sort needn't take place while stock is being taken of where we have reached. And so it doesn't sound as if anybody is in difficulty with there being a stay in relation to the step of notifying the registrar. That's a step taken by the court, and the court simply won't do it until the stay is by one means or other expired or extended. The other matters concern welfare issues, parental responsibility being a headline, one of those. And at the moment, I can quite see that the judge, if she was making a welfare order, would be mindful of the fact that, at least theoretically, there's a further road to travel before the proceedings can be considered to be definitively ended. But in common with what you say, although it be a matter for her, I can't see that it necessarily inhibits her from drawing such conclusions about welfare or making such orders as she thinks appropriate in the light of the situation she finds herself in. So I don't really see that the existence of a stay is likely to mean that the hearing that's about to start in front of her can't be put to best use. I mean, clearly she might decide, for example, that if she was going to make any orders, she could stay those for the same length of time, so that a parental responsibility order would kick in 21 days or whatever it was, if that was what she was doing. But it's possible also that if she did find something that, speaking myself, I'm not seeing at the moment, namely that she was embarrassed by the existence of the stay, then an application could be made to us in writing to do something about it. If it turned out to have a consequence which we couldn't foresee. So I'll just confer, if I may, with my lady and my lord. I think we've granted. Yes. Thank you for your help on that. Professor George, we'll grant you your stay for 21 days from receipt of draft judgment. That is by way of extension of the existing stay. And if there are any unintended consequences from that, then you or any other party are welcome to approach the court to adjust that order.
Thank you.
Is there anything else?
My lord, no, my lady, thank you.
No. Well, thank you all very much indeed. And we'll try not to keep you waiting for too long for our reasons.
All rise.